we together can write a new chapter in the relationship between the Government of Canada and First Nations. And those aren't just words. This isn't an aspiration. This is the law. This is the law as it is written. The plan is embedded in the law itself. In many respects, this is the first federal legislation to put Indigenous economic growth at its core.
That was Prime Minister Mark Carney in his opening address to First Nations chiefs in Gatineau. Today is the second day of the Bill C-5 summit. The Prime Minister is meeting today with First Nations leaders who have traveled from across the country to voice their questions and concerns about the government's major projects bill. The government says the bill is necessary to combat Trump's tariff war, but Indigenous leaders say their voices were largely left out of the consultation process. On Tuesday, 9 Ontario First Nations filed a legal challenge against the legislation, saying it poses a clear and present danger to their self-determination rights. Well, we want to dig into the story a little bit deeper, and we have reached Kate Kempton. She is a lawyer representing the 9 First Nations challenging Bill C-5 and is senior counsel with Woodward and Company LLP. She is joining us from Toronto. Kate, thank you so much for joining us. You heard a little bit of the opening address from the Prime Minister. What's your reaction to what you heard? You were obviously listening to the entire speech as well.
Anger, disappointment, disgust. It isn't true, first of all, that it's built into the law. If the federal government and Prime Minister Carney really mean what they say, then they wouldn't put in these absolute power provisions in the law that provide Cabinet unfettered and uncontrolled power. That's what's written in the law. The actual content of the law itself, which we have to go by, says that Cabinet has unfettered, unrestricted power to approve national interest projects without needing to apply a whole bunch of other federal legislation to them. Legislation that would protect the environment, that would carry out assessments to understand what impacts might be to the environment and humans, so we know the kinds of decisions we're making and the implications and how to minimize or avoid them. That would waive the requirement for a number of permit applications to be applied for and conditions to be put on those. That's Section 22 of that Federal Building Canada Act. And Section 6 is a bias section that deems that all projects put forward are going to be approved. So it takes away the no alternative. And so, no, that it's a bunch of political propaganda. It's also very disappointing and maddening because they again, the Crown governments think that they throw a bunch of money at something, which is really what he's saying, that First Nations should and are going to walk away satisfied.
We have heard him say that, no projects have been identified yet, that the stakeholders will bring those projects forward. He talked about wanting to, build a better Canada for everyone, that First Nations would have, obviously a say as a stake. He referenced the Cedar LNG project as one of those. But you're saying his words aren't matching the actual words in the legislation. So that comes back to that trust. The words aren't matching what's being said with the actual paperwork.
That's right. Take out Section 6 and 22, and maybe then we'll sit down and talk with you. I'll also say that a number of things that this federal government seems to be taking credit for, First Nations ownership in major projects and revenue sharing from projects, has been around for 20 plus years. I myself as a lawyer have worked on well over 100 agreements between proponents as large as Enbridge Gas and pipeline companies and Hydro One Networks Inc., et cetera, for where First Nations own up to 50% and sometimes more equity in the project, and many, many other mining, hydro, and other impact benefit agreements where First Nations are getting compensation and revenue sharing payments for effectively the use of their homeland territories for these projects. And so We're already doing that. Thank you very much. First Nations on their own initiative have been doing this for decades. I'd like for the federal government to advance this by bringing First Nations to the decision-making table. That's what this is about.
Now, Kate, you said that you also named some sections that you would like to see removed from the legislation. There was a suggestion, at least by his own words in his opening statement, that this was about listening, that things can still change, that they want to have feedback. Do you think that that's not really true? That this is sort of more smoke and mirrors?
Well, to be fair to the federal government, we did just serve our case 3 days ago. So, they may not have had a chance fully to analyze it yet. Again, it's very difficult and frankly, grossly unfair for any Crown government to say to any First Nation, just trust us. This country is founded and grounded on 250 years of abuse of trust of First Nations, every single one of which will say they never agreed to give up their right to govern over their homeland territories and live their way of life as they choose, as they self-determine, to a foreign Crown government, which would have been foreign at the time. And that everything that's happened over the last 250 years is a fraud. And so when you look at that history, which is still alive today, for that Crown government to say, don't worry, just trust us, is offensive at best. And no, it doesn't match the content of the law, but we do hope that in the next few weeks to come, that the federal government will really listen to us. We're not seeking to tear up the whole thing. We are targeting those deeply offensive and offending provisions, and perhaps they are going to be prepared to listen to that. I don't know yet.
Do you think that, are you hopeful based on conversations that will happen today in Gatineau, or do you think potential for any change would be because of the court challenge?
Well, I'm hoping both. There's frankly incredibly powerful images of First Nations uniting across the land, sometimes with or without the rest of Canadians as allies, standing up and showing what, real caring for Mother Earth looks like, and what real caring for collective, union of people and non-people, non-humans looks like. And I'm hopeful that there's, some of that to come, and that the case itself has the effect. I'd love nothing better than to not have to litigate this. If a number of things over the next few weeks, has the desired effect, then great. Do me out of a job, please.
Kate Kempton is a lawyer representing 9 First Nations challenging Bill C-5. Grateful for your time this morning. Thank you.
Thank you.